This is breaking news from the Las Vegas Review-Journal, sponsored by Michael Gaughan's South Point Hotel, Casino, and Spa.
The Ruggs matter, the state of Nevada versus Henry Ruggs, case number 21CR050378.
Good morning, Your Honor. Dave Chesnoff, Rich Schoenfeld, appearing with our client, Mr. Ruggs. Good morning, Your Honor.
Good morning. All right, this is the multiple felony count case. An allegation from November of 2021. This case has a lengthy history. I presided over this case on November 3rd of 2021. I presided over a custody determination hearing in the initial appearance court. Thereafter, I assigned it to another judge. Eventually, after multiple proceedings here in the district court, the matter was reassigned to this department as the DUI department. On February 21st, I recused myself. February 21st of this year, I recused myself. And thereafter, the defense objected to my disqualification. There were proceedings held in district court. At a March 13th, 2023 hearing in district court, Judge Schwartz saw fit to send this back to this department, to reassign it back to this department for a follow-up. And I need some guidance here. The information that I have here is the court minutes from district court, the March 13th date. The court indicated that she did not know if I violated any rules, is not going to force me to keep the case if I don't think I should. There was a discussion regarding judicial canons. The district court found that the Justice Court Chief Judge Cruz has the administrative authority, found that the court did not believe that there was ex parte communication between Judge Bonaventure and Judge Cruz, and referred the matter back to Justice Court 9 for a follow-up. Thereafter, there was a further proceedings entered by the Justice Court Chief Judge on March 13th, that same day. All that indicates is pursuant to district court ruling, case reassigned to Justice Court Department 9.
So,
Is there a written order from district court?
No, Your Honor, but we can give you context, and I don't think Mr. Domino will disagree with what we're going to share.
Will there be a district court written order? It appears, I checked the district court case management system. There appears to be an entry for a proposed order, but nothing that I can view, and nothing that's been submitted to me. So is there a proposed order being prepared?
Not that we're aware of, and the court didn't direct us to, but Your Honor, when we came back to you after Judge Cruz agreed to an order from Judge Schwartz that you get the case again, we came into court and you announced that you were recusing. This is said with all due respect, Your Honor. It took us by surprise in light of the fact that Judge Cruz had agreed that it would come back here, and you said that you had spoken to Judge Cruz. So we had no notice. Mr. Schoenfeld is going to address with you what we believe the requirements are. We are not telling you that after analyzing the way in which someone recuses himself, you want to recuse yourself. That'll be your decision. But we believe, and Mr. Schoenfeld will explain to you. Go ahead, Richard. Tell them what it says.
So, Your Honor, under the Nevada Code of Judicial Conduct, Section 2.11, subsection 5, which is the basis upon which Your Honor disqualified yourself, there's two requirements. One is that the judicial candidate makes a public statement other than in a court proceeding, and two is that the statement commits or appears to commit the judge to reach a particular result or rule in a particular way in the proceedings or controversy. And when Your Honor made your oral pronouncement of disqualification, you had stated that during judicial endorsement meetings you had made statements regarding this case, but we don't know what the statements are. And then part two is that the statements would have to commit yourself to a position or a reasonable person to believe that you've committed to a position in the case. So the case law says that there has to be an adequate record for basis of disqualification. So we sought relief in terms of either, number one, the court making the record in support of what's required under 2.11 subsection 5, or two, If part 2 of the rule is not met, in other words, if the statements don't commit you to take a position in the case or cause a reasonable person to believe you've committed to take a position in the case, then you'd be able to rescind the order as disqualification would be required.
And Your Honor, we know you presided over the original bail, but beyond that, you were not involved in the litigation. So we have no idea what it is that you said that you think somebody would think was commenting on the case. Commenting on the bail is not determinative of a recusal. So that's why we've done this, Your Honor. And if we had had some notice, we might have been able to paper this, but we didn't. So, and at the time, you'll remember, Your Honor, we reserved our rights to address this because we were surprised.
And I see that there was a discussion at that district court hearing earlier this week that the canons do not, according to the minutes, the canons do not list out how a justice court judge is supposed to recuse. I'm not aware of any requirement that I put the reasons for my recusal on the record, or even give that to defense counsel or the state.
So, Your Honor, there's a
There's a case law.
There is a case, Your Honor. It's Ham. Let me see if I have the site here. I don't have the site with me in this pleading, Your Honor, but there is a case that we cited in our district court pleadings, referred to as the Ham case, where it was a writ taken up from a recusal where the Supreme Court found that the record for purposes of recusal was insufficient. And then there's the Canarelli case, which is approximately a year old from the Nevada Supreme Court, that starts with the premise that a court has the duty to preside over a case unless one of the judicial canons would require disqualification. And the canon itself, as stated, has a two-part requirement. One is the extrajudicial statement, and two is that it commits the court or cause a reasonable person to believe that the court's committed to a particular outcome. So I think that the case law, and I understand the court hasn't had the benefit of reviewing that case law, but the case law is clear that there has to be a basis in the record to support disqualification.
And I don't see anything in the minutes from district court instructing this court to make a more thorough record. Again, this was just sent back to me for a follow-up.
For the record, Your Honor, the district attorney's office, not Mr. Baumann, but another district attorney represented that they did not oppose our request.
Now, my understanding is they specifically did not take a position.
Your Honor, just so that it might be clear on the record, the district attorney's office in our capacity as criminal prosecutors take no position whatsoever in this controversy.
The
The
DA
district attorney who spoke works for our civil division, who represents Justice Court.
And she said that she had no opposition to the issue of it coming back for the purposes that we wanted, which was an explanation.
Or rescission.
Or,
Sorry? Or rescission of the order.
yeah.
Anything else, Adam?
The only other thing would be, they had no opposition to whatever you did with regard to either keeping the case or recusing yourself from the case, but understanding, and Judge Schwartz understood, we were asking for an explanation pursuant to the canons. And we may agree with you, Your Honor, that Justice Court has not had the procedures in place, but that doesn't mean, most respectfully, Your Honor, that the canons don't control. And
I've extensively reviewed the canons, and I'll briefly discuss my experience with disqualification. I've been on the bench for over 18 years. I've disqualified myself multiple times for multiple reasons. I normally do not give an explanation, and I know of no requirement that I give an explanation as to why I need to recuse. And the code is informative on this issue, and I'll go over the code a little bit in addition to what I indicated at that February 21st hearing. I did acknowledge the Nevada Code of Judicial Conduct, Rule 2.7, which is the responsibility to decide, indicating a judge shall hear and decide matters assigned to the judge except when disqualification is required by Rule 2.11 or other law. The comment there indicates that although there are times when disqualification is necessary to protect the rights of litigants and preserve public confidence in the independence, integrity, and impartiality of the judiciary, judges must be available to decide matters that come before the court. So this court fully acknowledges its responsibility to preside over courts, but this does indicate except when disqualification is required by Rule 2.11. Rule 2.10 prohibits a judge from making public statements that might reasonably be expected to affect the outcome or impair the fairness of a matter pending or impending in any court, or make any non-public statement that might substantially interfere with a fair hearing or trial. Rule 2.1 covers disqualification and requires a judge to disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned, and then lists a number of circumstances that might require disqualification. Rule 2.11A5 indicates that the judge, while a judge or judicial candidate has made a public statement other than in a court proceeding, judicial decision, or opinion that commits or appears to commit the judge to reach a particular result or rule in a particular way in the proceeding or controversy. Now, the comments to Rule 2.11 indicate that a judge is disqualified whenever the judge's impartiality might reasonably be questioned, regardless of whether any of those enumerated circumstances apply. I'll also note that the comments indicate that a judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. That's not the situation here. A motion to disqualify has not been filed here. Again, the issue here is whether I have a requirement to make a record on why I'm disqualified. The record I made, I believe, at the last court date was sufficient. After I presided over this case on November 3rd of 2021, I reassigned it to, at the time, the DUI department, which was Department 13. There was a case reassignment at the beginning of 2022. It got reassigned to Department 8. There were multiple proceedings during that year, and in 2023, this court was reassigned this caseload. I was up for re-election in 2022 and campaigned for that re-election. I had many meetings, interviews, and I believe I had been contacted and asked to discuss my decision in this case. And I did, openly, and with the understanding, and I always prefaced this with whoever I discussed it with, that I was not presiding over the case. I had limited involvement. My only involvement was going to be the initial appearance for a hearing, and then it would be reassigned. I really did not expect that I would ever be reassigned this case. After it was reassigned to me, I did meet with the chief judge just to ask the question, a procedural question. If I did decide to recuse myself, where would I reassign it? I was informed by the chief judge that it would be reassigned to the original track, which was track 3, Judge Letizia. Now again, as to the issue of whether I'm required to state the reasons for my disqualification, again, the court rules are informative. I'm referring to court rule, the Nevada Code of Judicial Conduct, Rule 2.11C, and I'll quote that into the record. I'll quote, "A judge subject to disqualification under this rule, other than for bias or prejudice under paragraph A1, may disclose on the record the basis of the judge's disqualification and may ask the parties and their lawyers to consider, outside the presence of the judge and court staff, court officials, and others subject to the judge's direction and control, whether to waive disqualification. If, following disclosure, the parties and lawyers agree without participation, by the judge or court staff, court officials, and others subject to the judge's direction and control, that the judge should not be disqualified, the judge may participate in the proceedings. The agreement shall be incorporated into the record of the proceedings. Now, that's permissive. I find that under the Nevada Code of Judicial Conduct, a judge is required to disqualify under certain circumstances. I believe I've met those circumstances. Whether to actually fully put on the record that that disqualification could be waived, that's totally discretionary under the court rules.
Your Honor,
and I'm not asking for discretion in this case. I've made a finding based on my conduct, based on the history of this case, based on the Code of Judicial Conduct, that disqualification is required. I believe the record that I previously made is sufficient. And again, I have not been instructed by a higher court to make a more thorough record.
Most respectfully, Your Honor, and I really mean that. One, why would Judge Schwartz remand it if she didn't want a better record? She knew of the Ham case. I'm going to like to give you the site. We found it for you, Your Honor. 93 Nevada 409. And I have a suggestion to the court with respect, if the court would read that case and you believe that that case changes your approach or your opinion on this, that you notify us and we come back, or we trail it at some point this morning. Or you do what you feel you need to do, Your Honor, but we don't agree, again, with due respect, Your Honor, to your analysis. We believe the Ham case is controlling. We believe Judge Schwartz intended this to come back to get an explanation, and I'm not going to say any more.
I just can't accept that Judge Schwartz sent this back for a more thorough examination.
Well, then what was
A more thorough record or explanation.
what? I'm not trying to have a dialogue with you, Your Honor, but why else would she send it back?
I really don't know. One moment.
Thank you.
I did also, in this case, review the original objection to my disqualification. I did not see that, it was a Ham case?
Correct.
I did not see the Ham case quoted in that.
Right, but we didn't know you were going to recuse yourself, Your Honor.
Well, this was after I recused, and you filed a written objection to my disqualification that went before Judge Letizia. She denied that, and then there was a writ.
She's the one who cited Ham to us, Your Honor, Judge Recusal, and then we raised it in district court.
And I am looking at the minutes from March 6th of this year. Judge Letizia did cite Ham. I am also looking at the district court case management system. There is an entry here for proposed order review. A proposed order was not submitted by either.
I think that was on the order shortening time, Your Honor. I don't think we got any direction to prepare an order.
Your Honor, I would agree. Again, not taking any position in the controversy that Judge Schwartz did not instruct either side to prepare an order.
I'll review the Ham decision and recall this case.
At a later date or this morning?
Well, you know, I've got a very busy calendar.
I understand.
It's going to be lengthy. Why don't I give you another date? Would you like to come back next week, a day next week?
Whatever's good for you, Your Honor.
All right. We'll pass this matter 1 week from today.
We'll do that.
March 22nd, 8 a.m.
You've been watching breaking news from the Las Vegas Review-Journal, sponsored by Michael Gaughan's South Point Hotel, Casino, and Spa.